In the 1970s, Sony developed a device called Betamax. This device can copy the content of a complete TV program to a blank tape. After its release, a group of film industry members led by Universal Studios and Walt Disney Company sued Sony for manufacturing a device that could be used for copyright infringement. Sony argued that this invention only had an individual to copy a single program in his own home and for his own use. However, film industry afraid that copy tape can be resold, which damaged their business. So what did the judge do? At first, they tried to determine whether making home copies of repeated personal use is an infringement or not. But then they decided the issue need not to be resolved, because the suit was not against home users, but against the producer of the technology that enabled them. As the film industry failed to prove that their business were harmed, the majority opinion appeared among judges. First, the technology of Betamax has significant non-infringing use. Second, actual harm to film industries was not provable. And third, Sony was not contributing to copyright infringement. On the other hand, there is a dissent state that the making of even a single unauthorized copy is prohibited, according to the right to reproduce the copyright work in copies or phonorecord. However, it is also stated in law that fair use may be found when a work is used for purposes such as criticism, comment, news, reporting, and teaching. Each of these uses reflects a common theme. It is a productive use, resulting in some added benefit to the public beyond that produced by the first author's work. Making private copies for individual use has added benefit, as home users can watch it in convenient time, rather than miss it, as known as time shifting. The winning of Sony changed the way people watch film and TV programs. Rather than destroying film studios, videotape sales become increasingly important to their revenue. Although the VCR received blame for a 25% decline in the summer of 1985 compared to 1984's and closing movie theaters, by 1987 it was credited with causing a record high box office, as videotape's popularity encouraged consumer interest in film and watching them in theaters. Cable movie channels worry about VCRs affecting subscriptions, but began to offer more films for owners who wanted to build a home library, even encouraging time shifting by broadcasting the movies during the night so VCRs could record them while their owners slept. By 1995, more than half of Hollywood's American revenue came from home video, compared to less than a quarter from movie theaters. Forbes wrote in 2001 that VCR was no longer believed to be the death knell of the movie business. Instead, it became its savior, because consumers much prefer buying or renting films to recording their own onto blank tapes. Pamela Samuelson has remarked that the Sony decision is the most significant legacy of Justice Stevens in the field of intellectual property law, and its significance is likely to continue in meditating dispute between copyright industry and creative information technology developers and users of information technology. Many of the same points of law that were litigious in this case are still being argued in various cases, particularly in light of recent peer-to-peer lawsuits. For example, in A&M Records Company versus Napster.